No, you cannot make the court your trustee. The court's role is to act as a referee, not as your lawyer and certainly not as your personal assistant or trustee. Sovereign citizens often claim this because, if a magistrate were considered the trustee of one of their accounts, it would create a clear conflict of interest. The magistrate would then have to recuse themselves, a new judge would be assigned, and that judge would face the same issue. This cycle would continue until there were no judges left to hear the case. While it may sound clever on paper, it doesn't work in reality.
Come on up. All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir. I'm representing myself.
All right. That's the officer's testimony. It's fairly straightforward. He pulled over the defendant, who failed to disclose that he had a corporal while carrying a concealed handgun. This is a direct violation of MCL Section 28.425b, which requires individuals to disclose their corporal when stopped by police while armed. A competent lawyer might have a valid legal strategy to challenge these allegations under certain circumstances. But let's see how a pro se defendant tries to defend himself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, but count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes.
You were suspected of a violation, illegal tint on your front windshield, as the officer stated, which is why he initiated the traffic stop. Now, you may believe you were pulled over because of your race, but as you yourself later acknowledge in this video, there was indeed tint on your front windshield. If that's true, how could the officer have known the color of your skin before stopping you?
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
No.
In that last segment, he presented both a strong and a weak argument. Let's start with the weak one. He claimed that the legality of the stop depended on the officer's statement that he didn't initially pull him over for window tint. First, he has no audio or video evidence to support that claim. Second, even if he did, it wouldn't matter. Admitting that there was tint on the front windshield, combined with the fact that any amount of tint on a front windshield is illegal in Michigan, already gives the officer probable cause to initiate the stop. The stronger argument he made was pointing out that the officers didn't actually test the windshield for tint. In theory, he could have said it had tint when it didn't, which might have helped him avoid the minor violation. However, that still doesn't excuse the other violations he committed.
You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir.
You have copies for the state?
Yes, I do.
That's the end of that video. This is one of those cases where I almost want to root for the guy. He seems young, somewhat intelligent, and this country could use more young, intelligent people making positive contributions to society instead of adopting sovereign citizen tactics. Now, on to the next case. A sovereign citizen from Wisconsin whose bond was revoked because he treated returning to court as optional rather than mandatory. As a result, he now has to attend future court appearances from jail.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk.
You file it. Go ahead.
For my release from the Bay County Jail today.
Okay.
That's the declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today.
It wasn't really against your will, was it? You just explained that a previous judge asked you questions, and you chose not to answer. That is considered contempt of court, specifically direct contempt if it happens in front of the judge, which can also be grounds for a bond violation. In other words, you'd be better off letting the public defender speak for you, because right now, you're your own worst enemy.
I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation. On the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December. When's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
If you were truly trying to do the right thing, you wouldn't have refused to answer the judge's questions. As I mentioned earlier, choosing not to answer is your right, but that choice carries legal consequences. Now that both sides have presented their arguments regarding bond, let's hear the judge's ruling.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did.
Actions have consequences. You say you want to be out of jail living your life, but you missed your court dates, refused to answer a judge's questions, and then had to be forced to participate in this hearing once you were in custody. It seems like you're exactly where the system expects you to be. That's the end of this video. If there are any future updates, I'll share them. If you enjoyed the video, hit the like button. If not, hit dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any new content. Thanks again to Raycon for sponsoring this video.